One of the landmark judgment and very famous judgment, Re-Beruberi Union and Exchange of Enclaves, the Honorable Supreme Court of India said that Article 3 of the Indian Constitution does not apply in the case of Union of Territories. The court said that alteration of Union Territories boundaries or names cannot be done under Article 3 of the Indian Constitution. After the judgment, the Constitution 18th Amendment Act 1966 was passed, which inserted explanation 1 and 2 to the Article 3. The amendment of Article 3 of the Indian Constitution was done in order to explain the term state in clauses A to E of Article 3, but not in the proviso, also includes Union Territories. Explanation 2 to the Article 3 provided that Indian Parliament also has power to form a new union territory by uniting a part of any state or union territory to any other state or union territory. Laws made under Article 2 and 3 of the Indian Constitution to provide for the amendment of the first and the fourth schedules and supplemental, incidental and consequential matters to be discussed. Now, Article 4 of the Indian Constitution, it provides that any law amending the boundaries of a state or a law ceding the territory of a state always requires an amendment to the Indian Constitution. Furthermore, the procedure prescribed by Article 368 would have to be followed. Article 4 of the Indian Constitution provides the laws made under Article 2 and 3 to provide for the amendment of the first and the fourth schedules and supplemental, incidental and consequential matters. And it provides that any law referred to in Article 2 or Article 3 shall contain such provisions for the amendment of the first schedule and the fourth schedule as may be necessary to give effect to the provisions of the law, and may also contain such supplemental, incidental and consequential provisions, including provisions as to representation in Parliament and in the legislature or legislatures of the state or states affected by such law as Parliament may deem necessary. No such law as aforesaid shall be deemed to be an amendment of this Constitution for the purpose of Article 368. In Re-Beruberi Union and Exchange of Enclaves, the Honorable Supreme Court of India held that the power to cede national territory cannot be read under the language of Article 3C. Parliament's power to diminish an area of a state under Article 3C of the Indian Constitution does not include the power to surrender Indian territory to a foreign state. The court said that the diminished area of any state remains the part of the Indian territory. But it does not mean that India has no power to acquire foreign territory and the power to cede national territory. The Honorable Supreme Court of India said that such powers can be exercised through the making of proper legislation. And for that matter, it is always mandatory and compulsory on the part of the Indian Parliament to adopt strict procedure of Article 368. In another case of Supreme Court, that is Ram Kishore Sen versus Union of India, it is also known as Barbary second case, in which the Honorable Supreme Court of India held that cessation of territory is different from settlement of boundary or bona fide mistakes on the boundary. The action of implementing an international tribunal's award over some boundary dispute is within the executive power of the government. In such situation, no constitutional amendment is required. Similarly, the Supreme Court in the case of Union of India versus Sukumar Sen Gupta held that where a territory was leased to the state of Bangladesh, it was not necessary to amend the Constitution of India. It was held that there was no cession of territory, there was no abandonment of sovereignty, and therefore no constitutional amendment was necessary. And in this present module, what we have discussed that the Parliament has the power to alter the boundaries of the states. They can make new states, they can alter the name of the states, and why we have used and why the constitution makers have used the word Union of States instead of Federation of States. And in this module we also tried to understand the recent things about the formation of states like the Telangana states, that whether the recommendations of the state legislature needs to be considered and needs to be compulsorily considered by the Indian Parliament or not. These are the recent issues. With this, I sum up this. Thanks.